Good day. Welcome to our lecture on the law on sales. In this lecture, we will focus on the contract of sale as defined under the Civil Code, and more importantly, we shall distinguish it from other contracts that, at first glance, may appear similar but which carry very different legal effects. Article 1458 of the Civil Code defines a contract of sale as one whereby one of the contracting parties obligates himself to transfer ownership of and deliver a determinate thing, while the other obligates himself to pay a price certain in money or its equivalent. Three key points must be emphasized here. First, it is consensual, perfected by mere consent. Second, it is onerous, there is always consideration. And third, it is a principal mode of transferring ownership. Now that we have defined what a contract of sale is, it is important to understand how it differs from other contracts that may appear similar at first glance. On this slide, you see the outline of our discussion. We will compare the contract of sale with agency to sell, with a contract for a piece of work, with barter, with Dation in payment, or Dación en Pago, with Pactum Commissorium, with a lease, and finally, with donation. Each of these contracts has its own defining characteristics, and distinguishing them from a contract of sale is critical. Why? Because although they may overlap in appearance, they have different legal effects, obligations, and consequences. As we go through each one, I want you to ask three guiding questions. Is ownership transferred? What is the consideration? Who bears the risk of loss? By applying these questions, you will see why a sale stands apart from these other contracts. Let us begin with our first comparison: contract of sale versus agency to sell. Article 1466 of the Civil Code provides, in construing a contract containing provisions characteristic of both the contract of sale and of the contract of agency to sell, the essential clauses of the whole instrument shall be considered. Under Article 1466, in an agency to sell, the agent sells on behalf of the principal. Ownership of the property never passes to the agent. Instead, the agent merely earns a commission. In contrast, in a true contract of sale, ownership passes to the buyer. For a contract of a piece of work, Article 1467 provides a contract for the delivery at a certain price of an article which the vendor in the ordinary course of his business manufactures or procures for the general market, whether the same is on hand at the time or not, is a contract of sale. But if the goods are to be manufactured specially for the customer and upon his special order, and not for the general market, it is a contract for a piece of work. Article 1467 provides that if an article is manufactured for the general market, the contract is considered a sale. However, if it is manufactured specially for a customer, based on specific instructions, then it is classified as a contract for a piece of work. The test, therefore, lies in whether the product is intended for general circulation or uniquely for one individual. In barter, Article 1468 provides, if the consideration of the contract consists partly in money, and partly in another thing, the transaction shall be characterized by the manifest intention of the parties. If such intention does not clearly appear, it shall be considered a barter if the value of the thing given as a part of the consideration exceeds the amount of the money or its equivalent. Otherwise, it is a sale. Article 1468 gives us the rule: if consideration is partly in money and partly in another thing, the intention of the parties governs. If the value of the thing given exceeds the amount of money, the transaction is barter. Otherwise, it is considered a sale. In essence, sale equals money as consideration. Barter equals goods exchanged for goods. Dation in payment is a mode of extinguishing an obligation whereby the debtor alienates property to the creditor in satisfaction of a debt in money. Here, the debtor transfers property to the creditor to extinguish a monetary obligation. Unlike a sale, its principal purpose is not the exchange of property, but the extinguishment of an existing debt. Pactum Commissorium is a stipulation in a pledge or mortgage contract that allows the creditor to automatically appropriate the property in case of non-payment. This is expressly prohibited by Article 2088 of the Civil Code, and therefore void. Unlike a valid sale, Pactum Commissorium is illegal because it unfairly transfers ownership without due process. A lease is a contract whereby one party binds himself to allow another the use or enjoyment of a thing, for a price certain and for a definite or indefinite period. The difference is crucial. In sale, ownership passes. In lease, only the use or enjoyment is transferred, never ownership. Finally, donation. A donation is an act of liberality, wherein a person gratuitously disposes of a thing or right in favor of another, who accepts it. In contrast, a contract of sale always requires consideration in money. Put simply, sale is onerous, while donation is gratuitous.